The individuals that entered your home, how do you know their name? If you do. Court does call the case of the People versus Julius Clay.
People. Sheriff Julia Kern, on behalf of Julius Clay, can you state your name for the record?
Thank you. Taking time for preliminary examination of the people. Ready to proceed.
Your Honor, we are ready to proceed. We're ready to begin. We will not be able to conclude today, unfortunately, because one of the deputies that has some of our information is not available, but we will be able to proceed today with the civilian witness. We'll be requesting an adjournment conclusion of our testimony. I was, after the state was set, Ms. Hughes did send me an email subsequent to that stating that she had learned that Deputy Luke would not be available today, that she believed that she would need him in order to conclude the exam. I did not have a particular response for that. I understand that that can occur. So I wasn't sure who the people were proceeding with for today, but we do intend to.
All right, so you don't have any objection to start. I mean, I would grant the adjournment.
I understand that, Your Honor. So I don't have a response to the fact that the people would do that. Okay,
did you want to start today? I mean, I realize it's sometimes a matter of preference. It may be what the defendant wishes to have happen. Did you want to begin today, or did you want me to? My next date, well, when do we know when the deputy's available?
Detective Luke will be back next week, Your Honor.
So just so that you know, I have time available. I could hear it 1 week from today and it would all be together, or I can break it apart. It's up. But if I adjourn it out, so that you also know, if I adjourn it out, it will be adjourned to June 11th.
May we approach, Your Honor?
This always happens with you, Julian. Yes. No, you always just want to talk to me. I know. Come on. But I'll come up and see Miss Landy. I don't. You all set? Okay, call your first witness.
You call Alan Duva.
Sir, please come forward and be sworn.
Before you take a seat, raise your right hand, please. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Have a seat.
You need to, yeah, he does.
Need you to state and spell your first and last name for the record.
Alan Duva, ALANE, is the name of you, B is in Victor, A.
All right, you may inquire.
Thank you, Your Honor. Mr. Duva, can you hear me okay? Excellent.
Was that a yes, sir? Okay, thank you.
Mr. Duva, where do you live? What lot number? Is that in Washtenaw County, state of Michigan? Were you living there on February 7th, 2024? Did something happen that day that it caused the police to show up to your home?
Yes, but morning, there was a knock at the door, and I answered it, and two men came in. Kim, the girl that was on the drug trailer, said that they were trying to chase the child.
Sustained.
So let's break that down a little bit. You said there was a knock at the door and two men came in. How did they come in?
It wasn't where I opened the screen door and they entered and went directly into the front bedroom, which is right next to the front door.
Did you invite them to come inside?
Not really.
Did you say anything to them? Did they make physical contact with your body when they came inside? What happened when they were already inside of your home?
Jim said that they were trying to take the child.
So
Sustained.
one of the things about these questions I'm going to ask you, we're not going to talk about anything that anybody except the men said or you said, okay? So what happened when they came inside? they went to the bedroom? Who was staying in that bedroom?
Kim,
What's Kim's last name?
trying to think of that.
How do you know Kim?
She was the daughter of one of
The daughter of one of your girlfriends? About how old do you think Kim is? Was there anyone else staying in the house? Any children?
yes.
Say it again for me, please.
Her son,
About how old is her son?
around 2.
So when the men went into the bedroom, without telling me what somebody said, what happened next?
Walked into the doorway and Julius Clay stood in front of me.
Objection, Your Honor. There's a total lack of foundation for that statement.
Sustained.
So there was somebody that stood in front of you. Do you see that person in the courtroom today?
I think so. I the person that I'm looking at.
Your Honor, may the people request that the defendant remove his mask to see if it's the same person that the witness saw that day?
Response.
There, to be frank with you, I find this, I guess I don't, I have to, he could not identify any other person. And it is highly suggested to have Mr. Clay sitting at this table, and somebody must have informed him of Mr. Clay's name, because that was never a part of any of these reports. And so I have great concerns about whether or not he's about to make a misidentification.
Do we have to go through my?
What? 1 second, sir. 1 second. Thank you.
What did you say? Do we have to go through your phone?
Yes, there's a number of conversations about this case. And
Okay,
their
hold on,
names-
sir. Pardon?
And their names been brought up.
Okay, but I think that complicates things even further. But for the purposes of looking at the identification, I don't want to know what was said, but who brought up the name to you? Um, as you sit here today, without those conversations or whatever else was said, as you sit here today, do you recall what the individuals entering the home looked like?
Someone, yeah.
Okay. And do you believe that as you sit here today, based upon seeing them, presumably on that day, that you could tell whether or not somebody was there?
Yes.
Is that absent the conversations that you had?
Yes.
So the individuals that entered your home, how do you know their name? If you do.
I know the first one of them is named Ryan. I can't.
Okay, but did you,
And the other one is Julia.
sir, you can stay right there. Let's take him back. Counsel, I want to see him.
Yes, sir.
Court is standing in recess.
All rise.
If we could have him brought out, yeah.
You don't want him brought out?
Well, the whole issue, if Mr. Duva is going to be excused for the moment so that we can change over.
Can we call the case, Your Honor?
Oh, I'm sorry.
Court recalls the case of Beaver versus Clay.
Ashley Londy for the people.
We have to explain why I have to stay back for the moment so we can sort through this issue.
All right, go ahead. What would you like to say?
Obviously, we got a right to hear concerns regarding potential for identification or misidentification of this witness. What I would ask at this time is that this witness be excused at this moment. I know that the exam is going to be adjourned to another date anyway, and I need to evaluate the testimony that was just received as well as next step for the defense regarding how I might handle that legally. And so in order to protect the record from what might be perceived as future taint, I would just ask Mr. Clay.
Understood. Right. All right. And I understand that. And just so that the record is clear, without going into the specifics, this court had heard the examination of the co-defendant. There are some concerns that the court has and should allow counsel for the defendant to explore regarding the purported, or what I suspect will be an in-court identification of the defendant in light of that testimony. I'll leave it there so that I don't say too much, but we'll do that. I will then excuse this witness.
Thank you, Your Honor. And as the people indicated in chambers, it is our intent to recall this person when this
Yes.
case is adjourned to on June 11th.
Yes. Thank you, sir. You may sit down. All right, he has now left the courtroom. We can bring the defendant out. We're on the record in the People versus Clay matter. The record should reflect that Mr. Clay is now present in the courtroom.
Thank you. I just may have one.
All right, let me call your next witness.
Thank you. The people called DeAndre Burton.
Sir, please come forward to be sworn.
Will you take a seat, raise your right hand? You solemnly swear to affirm the testimony about to give with the truth, the whole truth, and nothing but the truth, so help you God.
I did.
Have a seat. State, spell your first and last name for the record, please.
First name is Inhumane, E-R-E, last name Burton, B-U-R-T-O-N.
You may inquire.
Thank you. Sir, how are you employed?
I work for Washington Sheriff's Office.
In what capacity?
I work for the Police Services and the Deputy Sheriff.
How long have you been a deputy sheriff with the Washtenaw County Sheriff's Department?
2 years now.
Were you so employed on or about February 7th, 2024?
Yes,
What shift were you working that day?
in that shift.
And were you assigned to a specific area or what?
Yes, I was assigned to 6 Township Road Stroke.
Did you respond to an address on Julie Drive that night? Do you remember that address?
Yes, it was 9904 Judy Drive, lot 221.
Is that in Ypsilanti, Michigan, Washtenaw County, state of Michigan?
Yes.
What happened when you arrived at that scene?
The victim was pretty, she was crying, she was hysterical. She stated that her son was just dating by her child mother.
How many people were at that address when you responded there?
A total of 3.
How many males, how many females?
1 male, 2 females.
Did you happen to make contact with the male at that location?
No, my partner did.
Did you observe that male?
Yes, I did.
Did you later come to know his name?
Yes.
What was it?
Alan?
Alan? Did you observe any injuries on Alan?
Yes, he had an injury to his head,
Do you recall where?
like in the middle of his head.
Okay, you're using your hand and you're sort of circling around the back crown of your head. Is that correct? Can you describe the injury that you saw? Did you make contact with any suspects at that location? One moment, please.
Yes.
Pass the witness.
All right.
I have no questions for this witness. Your Honor.
All right. Thank you, Deputy. You may step down.
Thank you. Your Honor, I believe the date that court said was perhaps June 11th.
Yes. So we will stop this examination at this point. Preliminary examination will be adjourned. Court's continuation to June 11th, 2024 at 11 a.m.
11 a.m. Thank you, Your Honor.
Yes, before me. Thank you. Bond will continue at this time.
Thank you, Your Honor.
Did you explain to him why?
I'm sorry, Your Honor.
Mr. Clay, Bring him back out here. Where'd she go? That way. Mr. Clay, don't act that way in my courtroom. Ever, ever. I realize that you want this to proceed at a certain pace. Rest assured, part of the reason that the conference was taken in my chambers with your attorney was she was seeking to make sure that all of your rights were protected. You acting like that, quite frankly, and I hate putting it this way, but acting a fool leaving my courtroom does not help that circumstance. She will explain to you everything that's going on and why. So am I understood that you will not act that way ever again here?
Yes, sir. I apologize.
Thank you. He may go. Bond continue.
Your Honor, he was here.
Oh, man.
Oh, no.
And- Well, let me, let's just say this is a similar situation to one you had about 3 cases ago, where he was going to be sent across the street.
And so he,
Proactively went and did it on his own.
Oh, I think absolutely, yeah, no question.
so he's not here.
Well, let me go out in the hallway and see. He was here because I.
Go ahead. You can check away. It's just one of those days.
I think he's over there testing away.
Do you think so? Okay, I love the faith that Mr. Childers has in people. Oh, I think he's gone. I think he may be at the nearest beach he could find. He is gone. But his attorney stayed.
I stuck around.
Yeah, I know.
He's not, he's gone. David I. Goldstein to bring on behalf of the defendant. Yeah, I told him there was a community corrections violation, discussed it. I asked him if he was going to test dirty. He said probably for marijuana. So
So for marijuana, he left. Yeah. Preliminary examination being set. Defendant having failed to appear, bench warrant will issue for the defendant's failure to appear. I will indicate defendant was here and then left. Will issue immediately, no bond.
Protester, maybe he's.
No, Mr. Childers, leave it alone. Yeah, maybe a lot of things happen. Right. So.
There's Mr. Vitello. Mr. Vitello is walking right now.
Has he signed in advice or rights? Yes. Pardon? I'm sorry?
He's not.
Tella, on your case, has your client executed an advice or rights?
I don't believe so. Your Honor. We resolved that pretty quickly.
Okay. So I need him to sign an advice or rights.
That's taken care of now, Your Honor.
And I'm going back and start again. Yeah. Because this got weird fast. Here we go. Now we're talking. Oh my God.
Whatever you want. Whatever you want.
Where'd old Tella go? Seriously?
Fine, you're ready for the last one. Where it goes, Steve.
Yeah, that is it. Here we go. Court calls the case, People versus Theophilus. Man, let's get him out. So
Oh, you're on. Okay. The file for Mr. Howard Smith's gone
Oh, yeah. Why?
because I just got a text from him.
He's
don't want-
testing?
I don't want it texting. Not sexting, texting.
Oh,
Thanks for clearing that up. Okay, you got a text?
Your Honor.
Yes. Hold on. Hey. Okay. Court calls the case People versus Theophilus.
Absolutely, for the people.
David I. Golds, hearing on behalf of the defendant.
Theophilus Smith.
Thank you.
Your Honor, today's the date time set for preliminary examination. Unfortunately, Detective Van Alstine is not present. You understand he's on leave. And the domestic violence victim is also not present. We're requesting an adjournment.
Your Honor, Mr. Smith, just be quiet. Okay. Your Honor, as both this court and Ms. Lundy know, I'm generally very amenable. I'm very flexible because we all work together and try to get these things moving along. This is one time I am going to have to object, however. I've only been in this case since November, and I understand that a lot of the delays were not occasioned by either the people or Mr. Smith. We were waiting for the forensic center. And for whatever reason, they really dropped the ball. Although I guess it's not unusual these days. So then we withdrew the request for the referral. The court set this for exam on on April the 25th. So this matter has been set for almost a month now. And I'm not blaming Ms. Lundy, she knows that. But this matter should have been either should be ready to go, or I should have been notified prior to today. This isn't like Van Alstine got sick this morning or had an accident this morning. If he's on leave, somebody should have known that. And that should have been dealt with. And not only is he not here, but the complainant isn't here either. So I'm going to object.
You still have a place on Miller?
No,
No, no longer. Okay,
I lost my place, Your Honor,
got it. If you were out, where would you go?
to my mother's house,
Where's that?
Swan Creek, Ypsilanti.
Is that the 6988 McKean?
Yes, sir.
6988 McKean, lot 262.
Got it. Okay. Is this the only case holding you?
Yes, Your Honor. As far to my knowledge, yes.
Here's what I'll do. I will grant the people's request for an adjournment to June 11th, 2024 at 9 a.m. However, what I will do is I will reduce the defendant's bond to a $50,000 personal recognizance bond. However, prior to his release, the defendant will be fitted with a GPS home confinement tether where he'll, I guess, be at his mother's home, but he'll be confined to the home until this exam is concluded.
Thank you, Your Honor. I just want to make sure I heard June 11th.
June 11th.
Thank you, Your Honor.
Yes, sir. All right. You understand that, sir?
Yes, sir. You said PR?
Yes.
Well, it's a PR, but you're going to have a tether and you're going to be confined to your mother's home
Okay.
until you get back here for exam. Understood?
Yes.
All right. All the other conditions that were set still apply, sir.
I discussed the no contact with him, Your Honor. I think that's what the court's.
Yes.
Let's get my straight spray.
Huh? Yeah, right there. Okay. Court does call the case, People State of Michigan versus Reginald Harris.
Good morning, Your Honor. Laura Williams on behalf of the people.
And good morning, Your Honor. Assistant Public Defender, Otatella on behalf of Mr. Harris, who stands to my right.
All right. In this matter, I have a plea form before me that indicates that the defendant will be pleading no contest to the charge of aggravated assault, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
Yes, Your Honor.
All right. May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Reginald Harris.
All right. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of aggravated assault. That's a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. I also have to, do you understand what a no contest plea is?
Okay.
Well, let me explain a couple things about a no contest plea. The first thing you need to understand about a no contest plea is the court has been provided and has reviewed the police report in this matter, and I would take those facts and accept them as true to determine whether or not this offense was committed. You understand that? The other thing you need to understand is that it means a no contest plea that you're not further desirous or wanting to contest this charge. You understand that?
Yeah.
The other thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty to this offense. You understand that? You understand that, sir?
Yes.
Okay. I also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
All right. Any other questions you have about a no contest plea? No? All right. Sure to tell us the basis for the no contest plea.
Civil liability, Your Honor.
All right. Sir, to that charge, how do you plead?
No contest.
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question about any of those rights?
No.
All right. On the podium, please look, you'll see a copy of one. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights of that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today, which is actually other than what's been stated here today to get you to plead no contest?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because well, I won't ask that. Counsel, I have been provided Washington County Sheriff's Office report for their case number 22-104113 and have reviewed same. Any objection to the court having reviewed that report?
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
You're satisfied. Thank you, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
July 2nd at 9 a.m. before Judge Freshour.
July 2nd, 2024, 9 a.m.
Yes.
9 a.m. before Judge Freshour. Bond in this matter will continue. Thank you.
If I can I request him as my lawyer on the second?
What?
Can I request?
Request him as your lawyer?
Yeah.
I wouldn't want him. Why? Why? You really want him again?
Yes.
Really?
Yes.
Seriously?
Seriously.
I never heard that before about him.
Oh, yeah. They say it's the first time for everything.
Yeah, I guess so. I'm shocked. Write this down. We actually have somebody that really wants him.
He's a good lawyer.
He is?
Yeah.
Yeah. But nobody wanted him, almost like an orphan.
Well,
What?
I do.
You do?
Yeah.
Okay, well, until he found a home. Right. I joke. He is a very fine attorney, and Washington County is really fortunate to have him present now in this county as part of the public defender's office. The assignment of attorneys, however, is not up to me.
Oh, it's not.
Okay.
Oh.
I do know the person you can call to make it happen, but I ain't gonna say it.
Call.
No. All right. Take care.
All right.
No. Okay. Oh, good. I could have stayed in bed. Morning, Miss Lundy, Mr. Brown. Yeah, whatever, children. No, good morning. I meant, that's what I meant to say. Sometimes it comes out wrong. Are we ready on anything?
I'm ready. Would the court like me to put the waiver on the record?
Is that why she stood? Oh, she is always, no, I didn't say that. You are always so well prepared. Yes, you will.
Thank you. Good morning, Robert Ramsey, for people of this kind of people who wait in the conflict between this honorable court and office of defender. The people who know this conflict exists, they can stay with it for all cases today.
Mr. Brown.
Thank you. Lord Brown, the Chief Public Defender, we likewise do not believe that any conflict exists in this court hearing these matters involving the Office of the Public Defender. Your Honor, if a conflict were to arise, we'd waive that conflict so that this honorable court could hear these matters.
Thank you. Court, for its part, also does not believe that a conflict exists either under the Michigan court rules or the cases decided thereunder. To the extent a conflict exists, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Jacob Watkins.
Ashley Lonnie for the people.
We're ready. On Brown, the Public Defender appearing with him, Watkins, who's approaching. Mr. Watkins, state your name for the record.
Jacob Watkins.
Your Honor, today is the date and time set for a preliminary examination. We are referring Mr. Watkins to the mental health court based on the information involved in this case. We think that's appropriate. We'd ask for, and does the court have that referral?
I do have the referral. I would need the prosecutor's signature on it. Has he started the process yet or no?
Right.
No? Okay. I've signed the referral and Brendan's signature on that. How much time do you think we'll need?
It's hard to say. I think probably 4 to 6 weeks should be it.
Wow. Okay, hold on. I mean, I can set this at any time. I can do, for me, I have June 11th, which may be too soon, and I have July 9th.
July 9th is probably.
July 9th.
It would ask for a PCC date rather than a preliminary examination date, if that's okay.
I don't go backwards. You know that.
Oh, you don't want to go back?
I don't go backwards. So I'll set it for PE that day.
We should accomplish the same thing.
And if something comes up, you guys can motion it up, and put it on my docket, and we'll figure it out. Okay. Preliminary examination will be July 9th, 2024, 9 a.m. That's before me in person. And the people don't need to have their witnesses present for that.
Thank you, Your Honor.
Yeah, that's fair. Thank you.
Bond will continue. Case of People versus Stephen Ruggs.
She just walked out.
Ms. Julian, if you see Ms. Solana Reed on the way out, please let her know we're waiting on her.
Yes, Your Honor.
She just walked out.
Sir, if you do me a favor and step to that side, thank you.
Good morning, Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs.
All right. This is going to be a waiver.
That is correct.
Mr. Ruggs, you signed this examination waiver?
Yes, I did, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Street.
Thank you. We would acknowledge receipt of the information, waive any further reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
27th at 1:30 before Judge Slate Thursday.
June 27, 2024, 1:30 Slate Thursday. Bond with its conditions will continue. Thank you. Yes.
Report the note in my file from the other APA that you saw in violation you passed today.
Yeah.
The May 17th, 2024 bond violation report.
I do. Is there a reason why you were missing? You were testing elsewhere, weren't you?
No, sir. I was told I needed a court order, and I was on video Zoom with you on my last court order, and nobody contacted me and told me where to go.
Why didn't they?
I do have information about a facility that he would like to test at. He lived in Macomb County. We
I'm on GPS. Oh, I'm sorry.
called them and they indicated as long as the order indicates what sort of panel needs testing and the frequency.
Well, that was supposed to be done before. If I give you a test today, are you going to test?
Yeah, the only thing I'm gonna fail for would be marijuana. Yeah.
Why are you using that?
Can I speak freely?
Yes.
Your Honor, I'm gonna be upfront honest with you. I used to have a crack cocaine addiction, and I've come a long way. I've been through a lot, this past few months. I lost my father, my grandmother. And there's no excuses. It's just the only thing that I've helped to
Give me an order. Okay, he's gonna go over to community corrections test today. I'll get the results and then I'll determine what his bond will be as he proceeds up, because he's told me what's gonna happen, and then we'll figure out, in the meantime, council can prepare an order so that he can test in Macomb.
Thank you,
Okay,
Your Honor. And then just to be clear for the record, the waiver is complete and we're only coming back on whether or not he'll be remanded.
pardon?
The waiver's all set now.
Well, technically, no.
Got it.
Because, technically to retain jurisdiction, but I still have jurisdiction anyway. So he needs to go over and test, and then we'll figure out what we're gonna do.
Okay,
Thank you, Your Honor.
thank you.
Thank you.
Remind me, because I'm doing a one-time on that.
Okay.
But then when I complete it, I'm gonna have to put it back on whatever I had. Right?
Here.
Yeah? What was that on? It's coming back in. Oh boy. It's gonna be that day. She said you're under, and then. What's wrong?
I just bring surprises.
Yeah,
Is that file still in the courtroom, correct?
pardon?
Is that file still in the courtroom?
Yeah, I'm sitting here right with me.
We could recall it whenever you have the opportunity. That'd be wonderful.
I want a court recalls case. People versus Ruggs.
Thank you, Your Honor. Nicole Hughes on behalf of the people.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs.
As we were walking out of the courtroom, I went to release the deputy who is present. I did not believe that the victim of the domestic violence was present today because she didn't check in with us. As we were leaving, the deputy let me know that the victim was actually present today with the defendant sitting beside him. As we exited into the hallway so that I could see who the deputy was referring to, the defendant was speaking to Ms. Perkins out in the hallway, and the deputy confirmed that that is the victim. There, as I understand it, based on everything that's filed, there's a no contact order. In that, in addition to the corrections violation, I'm requesting that he be remanded and that his bond be revoked.
That's not my problem. She was in court.
Mr. Allen, thank you, sir.
Your Honor, I have no further information at this time.
Does he admit to the violation?
You're on. Actually,
If you wish.
she wasn't here with me today, Your Honor.
Were you talking to her in the hallway?
She made a comment to her in the hallway. We were talking to her about testing and I said something that I didn't.
Were you sitting next to each other in the courtroom? You know I can get video from the courtroom.
Oh, yeah, I
So-
understand that. Yeah, she was sitting next to me.
You're not to have contact with her. You know that. Forget the testing. Defendant's bond at this time is revoked. Defendant's remanded. It'd just go up before Judge Slay. I'll just leave it there.
Thank you.
Your Honor. Yeah.
No. Yeah. They got one at the door, not one I sent. Okay. Court does call the case, People versus Emmanuel Henry. You can have a seat right there. Is Miss Gaines around?
I've seen her.
That's probably, I'm just trying to put this one underneath it so you have a pile.
Is on the plate.
So-
Both out.
Yes.
This is a waiver. Mr. Henry's a waiver. Is that what you're doing? Mr. Hanson, he's a waiver.
Yes.
As soon as we can get an attorney in here for him. Were you speaking with somebody today? She was here, okay. I hadn't seen her today, so I wasn't sure. Next door, is she, Miss Lundy, if you see Miss Gaines, can you?
I have seen her this morning. I'll go check the hallway again.
Well, you're better than me. I haven't seen her this morning. There's anybody from the public defender's office. Yeah, find somebody.
See anybody out there?
It's, from my understanding, it's a waiver. I don't, no, it's not? Okay. And I'm wrong. Well, that's what we had heard, but I don't know. Brendan is shaking his head no.
Ms. Gates has indicated she's on her way. She's.
Joy Gaines, Senior Assistant Public Defender. Okay, all right. Your Honor, we were initially going to waive the preliminary examination.
That's what I understood.
I'm sorry.
That's what I understood, but
Yes, at this time, my client is indicating that he no longer wishes to waive.
okay. So what are we gonna do? We're gonna have it?
We are ready to have.
Well, he's gonna have to go back because I'm gonna handle these other matters. I brought it out because I thought it was a quick matter. So take him back.
Thank you.